Welcome everyone to our webinar on virtual meetings, CC&Rs, and state statutes. We're happy to have so many of you join us this morning. My name is Mindy Knutson. I'm the Executive Director for the Utah chapter of CAI. And we just have a few announcements this morning to get started. We'd like to thank our diamond sponsors. We have Advanced Community Services, and we also have FCS Community Management. And we want to give another big thank you to our exhibit sponsor for today, Union Bank. And Union Bank has been a leader in homeowner association banking for more than 25 years by building long-term partnerships with management companies and the communities they serve. Because we understand the dynamic between community management companies and associations, we have the ability to provide service to both in a seamless way. By working with management companies as a conduit, associations can streamline processes and functions timely and easily related to their banking needs. Union Bank has been a proud partner with CAI for decades and has built a trust that is beneficial to associations nationwide. Our mission is to be the world's most trusted financial institution. And so we will thank you, Union Bank. We appreciate your support, and we will turn the time over to Neil Schiffman, who is our moderator today, and he will introduce our topic and our panelists.
Yes, thank you, Mindy. So I'm Neil. I'm going to be moderating our webinar today. So if you do have any questions during the presentation, please put those in the questions box, and I'll be checking those. If I need to interrupt the panelists to answer the question, I will do that. And of course, there's always a potential that they will answer those questions as they go. But our two panelists today, we have Blake Johnson, who's an attorney with Smith Knowles. Blake Johnson has been practicing real estate law since 2010, beginning in Oregon and then here in Utah since 2016, when he joined the Smith Knowles law firm in Ogden. He has experience in community association law, real estate contracts, financing, property rights, and litigation. In recent years, Mr. Johnson has focused his real estate practice primarily on community associations, working with communities and developers in drafting governing documents, amendments, financing due diligence, and providing counsel at board member meetings. The other panelist is John Richards. He's an attorney with Richards Law. John has practiced community association law since 1999 and is admitted, to CAI's College of Community Lawyers and is a frequent lecturer on community association topics throughout the state and nationwide. John is regularly asked to speak at community events and to teach courses for continuing legal education credit to other attorneys. John is a past president of the Utah chapter of CAI, served on the UC CAI board for several years, and served for many years on the Legislative Action Committee. So thank you so much for participating. John, go ahead.
All right. I hope I'm coming through, and welcome everybody. This is obviously
that's fine.
Great. It's an exciting opportunity to address so many of you. There's 100+ on this virtual meeting, and this is precisely the topic we'll be talking about: virtual meetings, electronic meetings, and how your owner associations are dealing with the pandemic. For one, the first issue being all of your clients are required by statute to have annual board meetings, so that's at least one, obviously. Usually they have monthly or quarterly board meetings. So how do we handle those right now? And then, of course, we all know that you're required to have, by statute, at least one annual meeting. But in the year 2020, how do we address that? And so we're going to be getting into that in just a moment. You're going to find that as we go through some of the slides here in a moment, that the general topics will start to repeat themselves. That's an indication to you that we've kind of exhausted the topics, but the issues that come with those topics are so complex and so diverse that we've got far more time, or far more issues to discuss than we're going to have time today. But our goal is through CAI and with Blake and with the chapter, both nationally and locally, is to give everybody some talking points that give you enough information to guide your boards through this crazy year and what implications this has on next year. So we'll go ahead and I'll see if I can advance this slide. If not, there we go. Okay, so like I said, you're going to see some repetitive text in my slides, but we'll get through all the information eventually. So the first question that comes to mind is, what is the difference between a virtual and electronic action or electronic means? For those of you who've been in the industry for a while, you know that we have statutes that actually allow certain things to be done by electronic means. And again, it does not say virtual, it says electronic means. And if I were to look at a few things, our open board meeting statute allows for owners to have if a fellow board member can participate via electronic means, then you have to open up the meeting for anybody else that wants to attend by that same type of electronic means. And usually that's a telephone call in the historic context of the open meeting statute, like a speakerphone call. We'll talk about Zoom and Teams and all these other platforms in just a second. But we also have another existing statute that talks about notice being provided electronically. Well, how does that, relate to virtual? And we'll talk about that in a second. We've got another statute in the Nonprofit Act that talks about the board can conduct any meeting through any means possible at which all board members can hear each other. That's more in the nature of electronic means. And then finally, actually, that's a little bit different. That's about record production that can be produced in electronic format. So the bottom line is this whole idea of electronic means is not new, but I do believe it's anticipated in the past. Telephonic call-in type communications, where if one person is participating by a remote call-in number, then you have to give the call-in number to others. Now we are in this situation, and I think we're all going to agree that heading forward, this is the way to do a lot of our meetings, board meetings and annual member meetings. In fact, you'll see in a slide here in a moment that I've never seen bigger participation. We've had communities of 300 people that they're lucky to get a quorum, which might be a 25% quorum requirement. And now we've got 200 people showing up electronically. It's been absolutely astounding to see. So the difference, of course, is virtual implies a lot more than electronic. I think electronic actions could contemplate email, but historically it's meant telephonic. But virtual now means these platforms where you can speak, you can have you're visually projected, like we're doing right now, and you have all these new tools to like raise your hand or to put a comment in the section. So just understand that I think we all get what virtual means, but electronic historically has meant telephonic and perhaps some email. And I'll talk to you about some problems that I've seen and some areas where, frankly, I've advised clients it's okay to assume some risk by using electronic means. But this whole new world of virtual means has opened up another Pandora's box of questions that we'll get to shortly. The next part here is let's look at arguments in favor of electronic actions under Utah law and concerns of taking electronic action under Utah law. One of the biggest lessons that I've learned is that, in fact, I learned this the hard way, and if any of you have litigated with our friend, he even might be on the call, I'm giving him a good plug here. If any of you have ever litigated against Joe Rona in Park City, you will know he is a fantastic litigator. I've even told him that to his face. He has undone, because of he has undone board elections and annual meeting actions in some of my Park City client cases. And now, a little disclaimer: I got involved after the problem erupted. But nevertheless, a problem erupts and a question has come up about the vote, especially for the management committee or the board, or maybe a budgetary item or an expenditure or increasing dues, a special assessment, whatever it may be. And they used email to receive many votes back. The bylaws didn't authorize it. And so, sticking to this current slide, arguments in favor of electronic action, it's more participation. And isn't that what we're all about? Getting owners to vote, hearing from them. Concerns of taking electronic action are just what Mr. Rona pointed out in court on a couple different occasions, that, hey, look, Judge, the bylaws say voting is in person or by proxy only, period. And that argument, depending on how your bylaws are written, has had some merit and actually did result in a 5-year-old decision being overturned. And by that point, it was water under the bridge. But the net result for his client was the board got vindication. The board got a big slap on the wrist, but the owner got attorney fees back for bringing this lawsuit and undoing some things. So my point is, we need to be very, very careful, and this will lead into another slide in just a moment, that even though I imagine right this very second, many of your clients, not just because of COVID, but even pre-pandemic, your boards were taking decisions or making decisions by email. That's alarming. We'll get to that a little bit more. But your annual meeting, people were voting and using email and getting results and tabulating those and counting them towards the final tally for whatever the issue was. There have been some challenges, but I will be the first to say that I have also been on the flip side of that, where we've done a risk analysis, and as long as the board has not had significant concerns about owners challenging the use of email to vote, they've assumed some risk, and many things have not turned into problems. But that's a very sensitive issue. So if you're counsel for associations wanting to use email, and you've got no mention of email in your governing documents, namely your bylaws, that's just something you want to pay extra attention to, especially where it says the voting means are in person or proxy only. As I mentioned just a little bit ago, and if you look at, and I don't have a slide for this, but just take note of Title 57, Chapter 8.8, Section 214. That's the Community Association Act. And then in 57-8-42, we actually, and this came about when I was sitting on the LAC, and I attribute some of the great minds out there, Quinn Sperry, John Morris, Lamond, all the other from the insurance world, but all the other great attorneys on that committee, to have a little bit of foresight as we got into, well, let's avoid the voting question for a second. Let's talk about notice, because every year you have to give notice of your annual meeting, and then on a regular schedule, there's a notice requirement for board meetings, especially if owners have requested to be invited to board meetings. You have an obligation to invite them. So if we look at 214 subsection 3, I'll just read it. There's a companion statute in the Condo Act, and I've just given you that site. It does say that if provided in the declaration, articles, bylaws, and this is the biggie, or rules of an association may provide notice. Remember, that's not voting. Notice by electronic means, including text message, email, or the association's website. So just focusing on notice for a moment, we had a lot of foresight on the committee to think, you know what, you can even give somebody, as long as you give the advanced notice required, your documents are going to give minimum of 10 days, minimum 15 days, no more than 50 days, or whatever they say. But if you're within that window, you can give notice by text message, post it on your website and call that good, or email. So I think we've covered, for the most part, notice electronically. And that's that next part there, emails, websites, but getting into just a general discussion of virtual platforms, email, and electronic surveys. That's where I think we'll spend, if we can go to the next slide, we'll spend a little more time on the use of email surveys and virtual platforms for voting. So go ahead, and I'll see if I can advance this slide, if I learned how to do that this morning. There we go. So one of the things that I'm seeing more and more now, obviously I think all of you are, is, hey, it's time for the annual meeting, and the question comes to you, what do we do? Because the truth of the matter is, everyone's a little bit nervous, especially on the attorney side, that we're advising associations to do things either virtually or a combination of virtually and electronically, and these types of procedures are not contemplated in our bylaws. So how do we ensure the legality of the process? If you want to absolutely bulletproof your process this year in 2020, here's my advice, and I will stand subject to scrutiny on this, but my advice is not defer it till next year, because we have to now articulate why we didn't do it in 2020. And you all know the obvious response to that. It's COVID. We can't. But I've had some pushback on, and even in my own mind, I'm thinking, yeah, but if I advise people, boards, to hold everything till next year, we certainly know that there is a requirement to do it, but I think I can talk around that due to the pandemic and the gathering requirements. But the problem that I'm seeing more and more is people want to get these annual meetings done, because if they don't take care of their election in 2020, by the time you get into 2021, your whole board system of rotation, it's all messed up. And you have to come up with a new system of figuring out whose terms really do expire. How do you stay on your stagger rotation for board members and things like that? And I had an issue come up about 3 months ago where, again, I got involved after the threat was made, but the manager had announced that they're going to just push the annual meeting to 2021. It's too hard. They actually had tried to schedule it in March. It was set for March, and then they tried to do it in May. They postponed, and then they were going to do it again in like August after kind of the vacation season was over. It never worked. So finally they said, we are bagging it. We're going to do everything next year. And then immediately an owner writes and says, if you do that, I'm going to challenge any seats that expired. And if any board member stayed on who should have gone off in 2021, I'm going to challenge every decision that they made. Now, I knew that this homeowner was overreacting. I also knew this homeowner had an agenda and was targeting this board member. But it really got me thinking about, can we, as the board, through our advice or through the management company advice, really in good faith say, board, that even though your 1 or 2 seats are expiring, they still have authority to bind the association next year, even though their seat has expired. And normally I would say that's no big deal. Of course they do. The pandemic is the reason, or it's the excuse to give. No court in the world is going to undo a board decision if they just bumped the annual meeting until the pandemic was over. But what I started wrestling with is most of your associations are authorized to take action without a meeting, to use under the Nonprofit Act 166A, 707, or 709, where you can conduct a lot of business by mail-in ballot. And I'll just give you, and I'll probably skip through a lot of the proper sequence of my slides, but I'll just give you what I've been doing to address how do you hold a meeting in 2020 when it makes more sense to do it in 2021, but you want to avoid the headaches of challenges. You don't want any board member's authority to be scrutinized, and you just want to get it over with. So looking back at this current slide, just make sure I don't miss anything too much. So ensure the legality of the process. In my opinion, you've got 2 choices to make. One, you either say we're going to push it to 2021, and if anybody alleges anything contrary, we're just going to argue that COVID is the basis. End of story. 2021, board members remain in office. We're going to send out a notification letter explaining this, and I bet you that 90% of your communities will not have a problem with this. However, because I've dealt with it a few times already, the other option, so option number 1 is push to 2021. Option number 2, in my view, is to go ahead and conduct your annual meeting this year. And it's easy, in my view, if you don't have any seats up. Now, this is skirting some of the technicalities of an annual meeting, but I think it would survive scrutiny if there's no voting. So if you're not voting on anything, and remember, some of your documents require budgets to be ratified. You have a provision to ratify the reserve fund contribution in the code now. But what I've told many people is, again, if you're not voting on officers, you don't have to approve the agenda. There's no special assessment. If it's really just an informational owner meeting, then do this. Hold it. Send out all of your financial statements, your president's report, last year's minutes, maybe a property manager update, so those types of documents that you would normally pass out at your annual meeting. Mail those out regular mail. So you can avoid this problem of, well, geez, not everyone has the capability to hop on a Zoom type call, or not everyone understands the technology. So hard mail it, United States mail. Make sure that they get the packet with a cover letter that says, in lieu of an annual meeting, here are our documents. Nothing's being voted on, but we encourage, but what I've been telling boards is to put in that cover letter with the packet the next board meeting, which might be scheduled for next month. It might be scheduled for January, and say, here's the call-in number, and please participate and answer any or ask any questions that you would have asked in the annual meeting at a board meeting. That's one way of getting an annual meeting completed if you've got nothing to vote on. If you have an annual meeting that has something to vote on, especially board or committee member seats, this is what we've been doing. We've been sending out that packet with all of the, again, the financials, the president's report, last year's minutes, and then a cover letter that says, oh, and then another insert that includes a nomination form. And the cover letter says, guess what, everybody, 2020 has been crazy. Here's all the information. We encourage questions of the board. Please ask. We'll ratify these minutes the next time we formally meet, but here's everything that you would have gotten at the annual meeting. However, we still have to elect 2 board seats. Enclosed is a nomination form. Please write in as many nominees as you like and return those by a date certain. This is all in the cover letter. And then the date certain, when the date certain comes by, the board sends out a ballot with the nominees that they've compiled. And so it's a 2-step process: informational with a nominee form, receive the nominations back, send them out via ballot, and do your election via mail-in ballot. The legality of this process, the number one on the side or on the slide, comes down to what your bylaws allow. But I think that any version of what I've just articulated will survive scrutiny if you're left explaining yourself to a judge, but at least you have your board elected. And I just think that's huge, to get your board elected. Remember that if you choose an option like this, where you're going to give notice and then receive nominees and then have a vote that still follows, it's more legwork. I get it, it's a pain, but to me, in many instances, it's worth resolving the election issue or the amendment vote on the documents or the special assessment vote. It's worth resolving those now. But if you'll see on my slide here, timeline, be sensitive to a timeline, because if you haven't had your annual meeting yet and you want to get a board in place by the end of the year, it's going to be difficult. Here we are, November 13th, with notice requirements. You need to be very sensitive to a timeline, especially if you're soliciting nominees to then send out a secondary ballot to vote on. Nominations, again, that's all about proper planning. Elections, how to conduct. I've kind of given you my version of how to hold a meeting in 2020, and that could include amendments to your governing documents. I've got 3 or 4 associations that are trying to amend and restate their entire CC&Rs right now outside of the context of an annual meeting, but nothing in their governing documents allows a Zoom type meeting to discuss the governing documents. So when in doubt, use the US mail. And if you're holding virtual meetings and that are not authorized in your documents, those are more informational. I don't think they're formal board meetings, and I don't think they're formal HOA meetings at this time, because and if we go to the next slide, let's see if I can get that up. If I hit that correctly, this has taught us something of tremendous value for the future. But I wanted to point out a couple of things that I want you to be thinking about. So again, look at your governing documents, and you'll see them here a little bit later, but the nonprofit statute, section 812, talks about electronic means, not virtual. The board meeting, the open board meeting statute, as I mentioned earlier, talks about electronic communications, and fair and reasonable notice can be conducted by electronic means. Again, website, text messages. So there's another statute that I'm just going to throw out there and have you guys think about, and it might show up on a later slide, its actual provisions, but it's Title 46. Yeah, down at the bottom there, Title 46, Chapter 4, and it's really 202. It starts on 101, but this is the Utah Electronic Transactions Act, and embedded in that is what I call the Utah Electronic Signatures Act. Basically, it says if it's permitted by law, the law recognizes an electronic signature as an authentic original signature. So as we're trying to weave in the use of email, and I mentioned briefly earlier, surveys. A lot of associations have gone to surveys. SurveyMonkey. There's another program called myelectionbuddy.com, and it's made for HOAs and HOA voting. That's what they're doing instead of holding annual meetings. And I think it passes scrutiny under the Electronic Transactions Act. We have the actions by written ballot, which is, this is something I want you to consider. I've taken the position, and it's kind of aggressive. And as we all know, as long as we've advised our clients to risk and potential consequences, and we've documented our files like crazy, you know, we can, they can assume some risk. So for example, let's say we start doing a lot of things by email or even survey. Action by written ballot, which many of you have probably used over the years for a mail-in vote for an amendment or what have you. In my opinion, and I'm comfortable arguing this in front of a court, is that action by written ballot in the year 2020, there's also action by mail-in ballot. I think that's what maybe it's called written ballot, but it contemplates mail-in ballot is what 709 does. In the year 2020 and going into 21, 22, you know, the future, in my opinion, a written ballot or a mail-in ballot is an email ballot. When this statute was written, it was only the U.S. mail, but this statute has got to be headed in the direction of electronic ballots. That raises a whole other issue of verification. Can we confirm who it came from? But right now, my point is, if you're using and accepting emails for votes, there's basis for challenge unless authorized in your bylaws. But there's a lot of good defenses, one being the Electronic Signatures Act or the Electronic Transactions Act, actions by written ballot, and just common sense at this point in time. So remember, we'll go to the next slide, but those are the statutes to take a look at that do have not virtual authority, but electronic authority. And we're getting close for Blake, and I am very anxious to Blake's presentation because he's going to be talking about, and I'll let him do it, when statutes trump, when statutes are discretionary to imply, or when they fill in the blanks if your documents are silent. So the moral of the story is, and I don't know if I had a slide for this, but if we brushed over it, it's my fault. The moral of the story is there's a huge thing that's been learned this year, and that is we need to update our bylaws. Our bylaw, all my bylaws now, and they have for some time because everyone wants to use email and surveys. All of my bylaws now have an electronic means, electronic clause, and it's not just for notice. That's what I want you to take away from this, is it allows voting by electronic means if you can put adequate safeguards in place so that you know that the sender is an actual owner. So there was one question that we received. I'll just try to address it now, and we can talk more later on this. Then I'll turn the time over to Blake. We know that management committee meetings and board meetings are open, and the statute says, hey, look, and we said this earlier, if a board member can call in, then anybody else has the same right to call in via the same way, or if they're dialing in, they get, a homeowner gets that same privilege. It also says in the statute that owners have a period of time where they can express any concerns or grievances or questions, and then the board can move on to business, but they have a window of time in all meetings. The question is a really good one that came up from one of you was, well, in these new virtual platforms, the board can make it so they have unfettered access to the panel, who's attending, all the comments, but they could also block. So let's say we had 5 people at a board meeting and they all had complaints. The administrator of that call, if done virtually, can block the other 4 and just give the platform to one person, but the other 4 didn't have a chance to hear the grievance. And is that permitted under the code? First, I don't think it's a violation of our open meeting law to do it that way. In other words, this homeowner who gave their grievance didn't have a chance to hear the other owner grievances. And in the normal context of a open meeting, in a conference call or just a regular meeting, all those in attendance would have had a chance to hear. I don't think, though, that just allowing someone to express their grievance and muting everybody else or even blocking them from hearing the grievance is a technical violation of the open meeting statute, but it's not good policy. We may see the statute changing accordingly. My bigger concern, as I started with, and it's which I'll end with, is I don't think that virtual meetings are authorized by the statute right now. Virtual board meetings or virtual owner meetings. We know that the open meeting statute allows for the board to take action without having a notice if you follow section 813 of the Nonprofit Act. So that it's complicated, but my point is be very careful using virtual means. Electronic means, we have limited guidance in the statutes that you saw a slide for earlier. I've given you some tips as to how to conduct an annual meeting if you want to get business done in 2020, which is my recommendation, but I just don't see a judge invalidating any postponement until 2021. But it's clear that our governing documents are inadequate to address a pandemic situation, and that will be a drafting consideration going forward. So that's a lot of hot air from me. Blake, I'm very curious and anxious to hear from you. And I'd like to thank everybody for participating, and I'll try to answer any questions that come up. And you can always call me afterwards, and I'll address these topics as well.
All right, Blake, real quick before you get started, there were a couple of questions that did come in.
Oh, and I've got a question too.
Right.
A comment, I should
say. So one of the questions was, does the notice for the annual meeting need to go out through USPS, or can it be electronic?
So the notice can be electronic. The notice can be a website, email, even a text message for the annual meeting.
Even if your governing documents state that it has to be sent via USPS.
So this is where Blake's going to dovetail, because the way that, that the statute reads, again, it's 16.6a. Oh, let me back up. So, oh yeah, so 812. Let me look at something more direct on point. Fair and reasonable notice. It does say right in the Community Association Act over here and the Condominium Ownership Act that if provided in the declaration, articles, bylaws, or rules, an association may provide notice by electronic means, including text messages, email, or the association's website. So you have to have it at least in your rules, which is easy, relatively speaking, to put into your rules. Some different things apply if you're a condo versus non-condo, but everyone should have a policy that says we can give notice electronically and have it adopted into your rules, and then you're good to go, at least on the notice issue.
Okay, perfect. And then the other question was, can they use a discussion chat board to bring up questions like what would be done verbally at a regular board meeting?
Again, remember, I have a problem. I mean, I actually personally don't have a problem, but considering the law, I'm concerned that any meetings or decisions that are done by a virtual platform are subject to challenge, because not everyone knows how to use a chat feature. Not everyone has a camera. Not everyone knows how to call in and use that properly. So to the extent the virtual meeting is deemed a valid meeting, I've got no problem with the chat, as long as the question's restated in front of all of those who are in attendance, and then it's addressed in front of everybody, not addressed to the questioner. It has to be addressed to the entire body.
Okay, wonderful. All right, so Blake, take it away. And anybody that has a question as the meeting is coming, as the webinar is coming to a close, if you'll type yes so that you have time to then ask your question. We don't want to cut anybody off early, but please feel free to ask those questions.
All right, perfect. Actually, I do have, for John, I was gonna ask, you know, this came up a number of times this year dealing with postponement of the annual meeting with elections, and you touched on that, and that member or that owner who wanted to challenge all of those decisions coming after the fact. That came up a few times, and what I've done, at least with the boards, is directed them to this language about directors and officers and Nonprofit Act about the terms of the directors, and this is in 16-6A-805, and it talks about the fact that the term of a director continues despite the expiration of the term, until you have that succession, until that new director is appointed or elected, or there's a decrease in members of the board. But again, it also defers to the bylaws. And so if you've got bylaws that say, you know, a board member has no authority after 1 calendar year in service, then arguably you could, I think the correct response would be, well, then that vote could be challenged, because by the terms of the bylaws, that person no longer has authority. But unless you have that language, and I don't see that kind of language very often, quite frankly, that limiting language, unless you have that language, we've taken the position that until you have a removal of that board member or an election, they still have voting authority. Now, the problem with that is that you're kind of putting the lid on the kettle as it's boiling, and you've got owners who are upset, and the longer that goes, the more likely they are to request a special meeting to remove a board member, and certainly that can happen. But that's at least the language that we've relied on to allow boards to continue to function, unless they got language otherwise. I don't know if you had any thoughts on that, but
Yeah, I do. So I have thoughts on that. And years ago, and when I say years ago, I'm talking like 19 years ago. And Lincoln Hobbs, if you're on the call, you told me this, but and it stuck with me. His phrase was, in the HOA context, even though people resign and quit all the time, unless they've moved, because they don't have any authority, certainly if they're no longer an owner, but they remain on the board until their successor's found. And so they may think they've resigned, or they may think their term's expired, but the truth is it's likely it hasn't, due to 815, which says you continue to serve until the replacement's found. The bigger issue in my mind is the psychological impact when you have a group of homeowners who's upset with the board. They're going to find, even though you're probably going to be able to prevail and say, we postponed the election for these valid reasons, that group of owners is going to cause so much grief. And in my view, sometimes, not every time, it's worth it to get that election done, just to take one of the arrows out of their quiver so they can't challenge the board. But I do agree, the term, and well, I bet many of you have had this. We, the board, are so pissed off are so upset at our membership, and no one thanks us. This is the worst job in the world. We all resign at the same time. They can't do that. They serve until their successors are found. But I have found that it's almost not worth it to have to say that, to explain to your membership, no. They really do serve until the replacements are found. And then when you have especially a group of 10 that want to get a board member off, it's not worth the hassle. But I agree with your conclusion. Practically speaking, it may be in the best interest to think of it a little bit differently, but you're right on your statutory interpretation.
Yeah, and it brings up a good point, that part of what we do, at least how we view it, is we're not just trying to find what is allowed and what's not allowed, but what's going to keep our association out of litigation. And that's to me probably the primary goal. And if so it is a balancing act. What can we do? What should we do? But at least during COVID, that's that reason has allowed us to delay to some extent.
Yep.
But I don't know if we have any. I've had a lot of board members talk about, well, we don't like the virtual meeting platform. It's not practical. It doesn't work. I don't know if you agree, but I get the feeling that the time for that type of an excuse for delay is probably past. I don't know if judges are really going to give us that much leeway anymore and say, well, look, these are options that are proven. Other associations are doing it. You guys need to be trying it as well. It worked for a while, but it doesn't seem like that's going to work anymore. We just need to move forward with doing our meetings.
Yep. My takeaway on that point is, talk to all of your boards. It's a good project for all of us, and it saves them a lot of heartache. Is get those bylaws updated to contemplate these scenarios.
Yeah.
So on the topic of the virtual and electronic meeting, would you distinguish the difference, or what is the reason, John, that you distinguish the difference between an electronic meeting versus a virtual meeting?
The only reason I tried to draw some sort of distinguishing feature is most everyone has a telephone. most everyone can call in and understand how a conference call works or a speakerphone works. This new platform of what we're doing right now, even though there is the opportunity to call in, it's new. It's newer to a lot of people, especially an older populace in some of our communities, whether it be a retirement community or whatnot. And so my concern is that there is sufficient reference to mail and then electronic means in these various statutes that we referred to. There's no reference to, oh, hop on this Zoom call and that will count as an electronic meeting. I do believe it falls under the umbrella of an electronic meeting. Don't get me wrong, but I think that if push comes to shove, a court would look at where we've called out electronic means specifically, and the question is, did those statutes contemplate a virtual platform? And I just don't think, I mean, we can argue it obviously, and technology is always changing, but I don't think the statutes contemplated this. So I don't know if homeowners are prepared for this type of meeting just yet. That's the distinction.
All right. Well, so the topic that John discussed kind of dovetails with the second portion of our presentation today, which is the balance between statutes and bylaws and declarations, and what can we do, what can't we do. One of the most frequent questions that we typically get as attorneys is from a manager or board member asking, can we XYZ? Or can the owner XYZ? What is allowed? And that process always requires us to go to multiple sources. You can't just go to the statute. You can't just go to the bylaws or the declaration in most cases. You really have to look at both, and you'll see why that's the case as we go through here. But we do have to take a look at, okay, what are we doing on the basic level of creating an association or running an association? What is it that we're doing? And at that basic level, really what we're doing is we're dealing with contracts. We're dealing with a contractual agreement between developers and owners and future owners. And so when we're talking about deferring, does the statute defer? We're talking about, does the statute defer the right to basically contract this provision or make an agreement on our own without the state really telling us what we have to do? So we're going to talk a little bit about different statutes that apply. We're going to be talking about the Community Associations Act, the Condominium Act, and the Nonprofit Act, and how that plays into our documents. What can we override in our documents? What can't we override? And so we'll take a look at that. And as a kind of a disclaimer, the statutes were not written to fit into boxes. They weren't saying, hey, we want to fit these into some nice, neat little categories. So these types of statutes that I've described here, these are mostly just from me observing how they apply and how they work, but they're very nuanced. And you'll see that part of a statute will defer to the governing documents, and part of it may not. And so you can't just say, okay, the section on reserve analysis defers or controls. It's more complicated, but for purposes of today, I'm going to try and touch on the most frequently used or discussed statutes and how they apply to our governing documents. So the first category you see here, I call it controlling. This is a statute that really doesn't give the HOA discretion to override this type of a statute. The second one would be a deferring statute, one that basically allows the HOA to draft what they want under this type of a provision. And number three is actually pretty similar to a deferring statute, but it's one that authorizes some sort of a use or some sort of an action, but then it gives you all sorts of limitations. And I'll talk about a couple of examples. And the reason I say it's pretty close to deferring is because if you're thinking about this in the context of we get to write whatever we want as long as the statutes don't say otherwise, and don't stop us from doing it, technically we already have that right. So when you see a statute that says you may do this, you may have this rental restriction policy, but here are these limitations. In all reality, we already had that right. We didn't need the statute to tell us we had that right. It's just a matter of, what are they going to limit us to? But for purposes of trying to read these statutes into categories, a lot of them just seem to authorize the HOA to do something, even though I believe that right exists otherwise. So we'll go to the next slide. I clicked it, but there's a delay, and I apologize if it looks like I'm sitting in a dark cave. I don't know what's going on with my lighting, but it seems dark on my end. Let's see, can we click to the next slide? There we go. So here are a couple of classic examples of these types of statutes. So the first one, this is going to be your budget statute, where it talks about this language here. It says, at least annually the board shall prepare a budget. That's something that we have to do. In the legal context, when we see the term shall in a statute, that doesn't really leave a lot of room for discretion. That's something we must do, right? So I would call that a controlling statute. This is an example of one of them. We're going to go through a lot of different statutes today and talk about whether or not they're controlling and deferring, but this is just one example. A deferring statute, at least under the Community Associations Act, would be the period of administrative control, right? We have a lot of discretion to describe in the declarance documents how long that period exists. With a caveat, there are limitations with condos, but when we're talking about these governed under the Community Associations Act, we can write that in. And so we see this language here that says, unless otherwise provided for in a declaration. This is some very, very easy to spot language in all of these statutes that if it exists, it basically says, these are some default rules, but if you guys have contracted or drafted otherwise, then that's going to control in most situations. So that's what I mean by deferring.
Hey Blake, can I interrupt? Do you mind if I ask a question while we're on that? This language has always driven me crazy, especially where we can substitute the word declaration for bylaws, unless otherwise provided in the bylaws. Do you think there's any merit and good faith argument that this section, this phrasing, unless otherwise provided in a declaration, really means unless otherwise prevented or unless otherwise prohibited for in a declaration, then ABC can occur. As an example, the mail-in ballot statute under the Nonprofit Act, it says unless otherwise provided in the bylaws, you can use the mails to conduct anything that can be conducted at any association meeting. Well, my bylaws do state otherwise. They state in person or by proxy. I would love to have a good faith argument that says unless this really means unless otherwise prohibited in the bylaws, which I know I'm reading a word in there, obviously, but it almost seems to me that if my bylaws say I can vote by in person or by proxy, period, this would not allow me to say, I can use some other statutory terms in addition to. Does that make sense?
Yeah, it makes sense. And the way I read that language is the way that I most commonly see it, which is going to be like in the Nonprofit Act, where the Nonprofit Act or the other statutes that create legal business entities, the for-profits, all that kind of stuff, they commonly have this same language, which is unless otherwise provided for. And we don't see it so much in the HOA world where you have HOAs that don't have bylaws. Most of the HOAs seem to have bylaws, but single member LLCs and things like that, they frequently don't have any bylaws or operating agreements. And so what these statutes do is they serve, in my opinion, they serve to be kind of like default bylaws. And so the way I approach a statute like this is this language will apply if I don't have language on point or that overrides this language. So whether or not it's only for limiting or whatnot, I see it as if you've addressed the topic in a way that conflicts this language, then your language will control. That's how I typically do that.
Thank you.
But it's up for debate. This is obviously, I don't think that some of these statutes are written with with those types of questions in mind, and we'll see that later on when we're talking about this. This third type here, authorizing, a classic example would be for the solar panel restrictions, where it talks about a declaration may, and then it goes on to describe these. You may have a solar panel restriction or solar collector restriction, but these are some limitations that have to apply. So as I said, I think we have the right to contract anything we want unless the statute says otherwise. So in some ways, we could even just call these statutes limiting statutes, where they limit some of the things that we could already do. And so it's kind of a hybrid between deferring and controlling. But you see that language sometimes, and quite frequently, the declaration or the bylaws may say something. And so I wanted to address it kind of like as a different category, because you're going to see that language and you want to be able to know how to address that. Let's go to the next slide. A classic example of what I'm talking about, as far as if there's no language on point, we really have the right to contract it, and it's deferring, would be for, say, the condominiums. There's no statute, at least in the Condo Act, that talks about rights for owners to be able, or limitations on associations to write rules restricting flags and stuff like that, at least not within that act. And so the lack of having any language in that code allows us to draft what we want, in my opinion. So that's kind of what I mean by this deferring. So if we look at what I've done, is because there's so much overlap between the Community Association Act and the Condominium Owners Act, I've tried to focus the presentation just on statutes that are in the Community Association Act, but then we'll talk about a couple sections of the Condo Act that conflicts or is different than what we're talking about here. Rather than talking about both of them, I'll talk about how the Condo Act is different. So some of these first statutes that we are looking at, these are the statutes in the Community Association Act that seem to clearly defer to the association to be able to write the rules that they want to write when it comes to their governing documents. And so if you look at 217, which is your rulemaking, let's see. It allows you to create these rules. Excuse me here. And this is where it's going to show that it's not very clear. You can't really categorize them too well. But the rulemaking period during the control period is basically whatever we want to do. If you look down at the bottom of that section, it talks about the fact that the declarant can exempt themselves from the rules in section 217. And so you don't have to provide the notices. You don't have to do all that kind of stuff if you are in that control period. But you'll notice that when we're talking about rules that control rulemaking, when you're not in the administrative control period, those rules are going to be controlled by the statute. You have to provide notice. You have to do stuff like this. So when we're talking about even within the same section, the very bottom section of this statute defers to the declarant to be able to do what they want. But when you're not in that period, then you've got this language above that describes the process for a rule to be created. Now, we don't see that same language in the Condo Act. We don't have those same restrictions when you're outside of that period of administrative control. And so we're a little bit more flexible to write those rules and create those rules without following these rules found in the Community Associations Act. And so in that sense, the Condo Act somewhat defers to the rulemaking process, whereas the Community Association Act is a little bit more strict when it comes to that. So let's look at another example of that would be eminent domain. If you're not familiar with the term eminent domain, That would be a situation where a local city or county comes in and they build a road through your community gardens, and they're obligated to compensate the owner for the taking of the land. And there's a whole process for that. But under the Community Associations Act, if you look at that statute, it says, let's see, unless the declaration provides otherwise, then you have to provide the payment for that taking equally among the lot owners in the communities in that association. And so in that situation, it's allowing the declaration to say otherwise. We could say it goes to the HOA general funds or what other language we want to use there. But if you look at the Condo Act, it's going to be a little bit different. It actually states that the portion of the money that comes from that government agency for that taking is actually going to go to the, let's see, I've got here, I've lost my slides. Let's see, do we see the slides there?
We can see the general menu of slides.
Okay, there we go. So when we look at the eminent domain section of the Condo Act, it's going to have a little bit different language where it doesn't give us that same discretion to be able to apply those funds other than what's stated in the statute. And so that's where it would control our situation, whereas the Community Act does not control the situation. Let's look at maintenance of common areas. We can take a look at that language specifically. I hope mostly you guys have access to a web browser. You guys can be clicking along in the code sections with us. But if we look at this section, we'll again find that same language. Let's see here. In subsection 2, except as otherwise provided in the declaration, that's our magic language. An association is responsible for the maintenance, repair, and replacement of common areas. And so what we typically would see in an association is you may have some areas of that common area that are going to be outside of this basic rule that the HOA maintains, that you may have some special provisions in there, and the statute seems to allow that. And so another example of how the statute allows the HOA to draft what we want to draft in order to best suit the needs of that particular type of a community. There's one that John and I were talking about before the presentation. Oh, let's see, I think we went one slide too many. Can we go back a slide? Okay, so these are some of the statutes that control, at least under the Community Association Act. We're talking about your fine process, the process in which you can turn those fines into liens, all that kind of stuff. One that we were talking about before the meeting is this, the reserve study statute. You can find that statute in subsection 211 if you go to it, and you'll see this language that we're talking about. Most of the time when we're talking about reserve studies, we talk about it in the sense of, oh, you got to do a reserve study every 6 years. That's what everyone says all the time. But if you look at the language in 211, it states in there, in subsection 2, except as otherwise provided in the governing documents. So there's that language again. A board shall cause a reserve analysis to be conducted no less frequently than every 6 years, and then talking about the updates. And so when you look at that language, it seems to open the door for us to say, look, if you're an association that's small or doesn't have common area or things like that, do you really have to have a reserve study? This statute seems to show us that no, you don't actually have to have a reserve study if you have it written in your bylaws, and that's the key. Anytime it's talking about unless otherwise provided in the governing documents, for something like this, you better have it in your bylaws, or your declaration, I should say, that says you guys don't have to have a reserve study, because otherwise you're going to be having owners looking at this statute, or owners talking to other people or managers and being told, look, we got to have a reserve study every 6 years. That's what HOAs do. So back to what John has been talking about, the need for good governing documents, amendments, things like that. If you are an association that's actually looking at not doing your 6-year reserve study, you better have that in your governing documents. Otherwise, you are required under this statute to do it. But again, that's a pretty broad power that the HOA has to avoid that reserve study. And it's one of those things that I have it listed under this section of control, mostly in the sense that, and John, you can speak to this. It sounds like you've had some litigation on this issue, but regardless of whether or not it's allowed, you're going to come into problems if you don't have some sort of reserve funds or reserve study if you have a need for it. And so, eliminating it altogether is probably not the best idea unless it's a very special circumstance. I don't know what your thoughts on that are, John.
I think you've captured everything that I would say as well. If you have it in your declaration, I believe you can have a zero funding requirement, but I can almost guarantee, because the mentality is this: we're wealthy, and when the time comes, just specially assess us. So we don't want to deal with the budget and a line item in the budget for reserves. We don't want to worry about a reserve study or updating it. Just assess us when it comes due. Well, if the documents allow it, that's a pretty good defense if you're challenged. But like you said earlier, one of our objectives is to keep our clients out of trouble or out of a challenge, even if we may win. And I can guarantee that someone's going to allege breach of fiduciary duty, failure to underfund, allowing too much deferred maintenance, if you have that clause. So I agree with everything you just said.
Okay. So if you go through, and if these are just samples of some statutes that have this controlling language, the very next section dealing with the required contents of a declaration, it uses that same language, shall, and it has a list of all the things you have to have in that declaration. So you see that throughout. One of the ones that I want to take a look at is section 218, dealing with the equal treatment of the rules in the association. And this is something that comes up from time to time. Let me pull it up here. So under the statute, we have the ability to write rules within the association, right? And we know that the rules have to equally treat the owners within the association to the extent possible. But if you look down at subsection 15, it states that a declaration or an amendment to a declaration may vary any of the requirements of subsections 1 through 13, dealing with this ability to write rules that may treat people differently. And so if you have something in your declaration that's been amended, voted by the members, but it happens to treat someone differently than another, say, Quinn Sperry could probably appreciate this one, the size of a fence, then if it's within the declaration, then that's going to override this requirement that everything has to be fair and equal because it's actually in the declaration. And I only call out Quinn just because we had a case that dealt with that, and this was certainly Quinn's position as well, that you can write it into the declaration. But that's basically an example of how you can have this language that controls in regards to the rules, but in declaration, they still allow us to have discretionary provisions within our declaration that override that provision, if that makes sense. Let's see, let's go to the next slide. Okay, actually, let's go to the next slide after that. since we're running a little bit short on time, let's talk about these that authorize the fees, or the authorize certain things. So for example, we talked about the rental restrictions in section 209. The rental restrictions, they authorize us to provide rental restrictions, but they provide us these certain limitations that apply. And if you look at the rental restriction statute, it's not the best language, I think, to at least explain to the associations when you have to, you're talking about exemptions that you have put into your declaration. I don't think it's the best language, but under that statute, we're allowed to, or we're required to put in these exemptions if certain conditions apply. So if you look at the section dealing with the term and the number of rentals, it says that if you have a restriction that limits the term and number of rentals, then you have to include these exemptions within your declaration. So it seemingly allows us to do these rental restrictions, even though, as I said, we already have that right to do a rental restriction. Really what this is doing is limiting our ability to do a rental restriction unless we meet certain criteria. And so under this type of a scenario, under this statute, if you're only restricting, say, the term of it, maybe you're only doing daily rentals, you're limiting daily rentals, but you're not saying you have a cap on how many units can rent, well, then you don't have to include all those exemptions if you don't want to. But this is an example of one of those statutes that seemingly authorizes, but it's going to create these limitations for us. Same with the solar restrictions and others. But what I want to do is I want to talk about the bylaws, because the bylaws under the Nonprofit Act, it treats things a little bit differently, because as I said, the Nonprofit Act is one of these statutes that helps create these entities. In this case, it's a nonprofit corporation, and there are other statutes that create LLCs and for-profit corporations, and they have these statutes in here, and you'll see this language where it says unless otherwise provided in the governing documents, or unless otherwise provided in the declaration. Usually in the Nonprofit Act, it's always saying unless otherwise provided for in the bylaws. When it says that language, that's our cue that we get to basically draft that language the way we want to. We can take a look at an example of that. Well, we looked at the action by ballot, the meetings by telecommunication, but let's look at the annual meeting section, because I think that's a pretty clear example of this. So if you go to 16-701, right there at the top of the statute, it says, unless the bylaws eliminate the requirement for holding an annual meeting, a nonprofit corporation that has voting members shall hold a meeting of the voting members annually. So what we see is that language repeatedly through the Nonprofit Act, talking about unless the bylaws say otherwise, or unless the bylaws do something. And the reason for that, I believe, is because the statute was written with one of the goals was to create kind of this default set of rules that apply to nonprofits that don't set up bylaws. And so that's why you see so many of these statutes that defer to the bylaws in determining what is allowed and what's not allowed. So if you just go through these different sections in the slides, and we could send you these slides, you'll see this language repeated through there, but that's not always the case. There are some statutes in there that control. But the key is when managers or board members come to us and they're saying, can we do X, Y, Z? Because, as you can see, they're so nuanced. These statutes have portions that are controlling and some that aren't controlling. We really have to go to both the governing documents and the statutes when we're determining what to do. Now, that's not always the case. I mean, I think most of the attorneys have these controlling statutes pretty well down because we deal with those all the time. But it's really complicated for us to come up with a simple answer sometimes when we have to go through both sections, and quite frankly, we have to look at the bylaws or the declaration in a lot of situations because of that basic contractual right that we have to write into these governing documents the things that we want to do. And so these slides kind of give you an outline of some of these statutes that we can, we are deferred the power to draft, or the statute overrides our ability to draft, or somewhere in between. But if you've got questions about it, then certainly I think the best approach is to contact the HOA's attorney to get some guidance on how that would apply in context of the governing documents. But as John said as well, a lot of these statutes talk about unless the bylaws say otherwise, or unless the declaration says otherwise. And so if you want that provision to give the HOA flexibility, or you want to write in something that benefits the HOA, then you got to have it in the bylaws. You got to have it in there. You should be writing it in there. Now, there are some situations where you're going to have HOAs that write more restrictive rules within their governing documents. For example, that same language that we looked at earlier about the reserve studies. If you have an association that writes in that they do a reserve study every 3 years and an update every other year or something like that, that language in the declaration is not going to conflict with the statute. And so in those situations, you can draft more limiting language if you want to, as long as it's not going to violate that statute. And so even with these statutes that control, if the HOA wants to get a little bit more creative or restrictive, as long as you're not defeating the purpose of that statute and you're not removing the protections that were put in place with that statute, then you see that language come up from time to time as well. I don't know if we have any questions about that.
Yeah, I was going to bring up a couple questions that have come in. One of them, somebody asked if you could define administrative control period. You talked about that in one of your slides, Blake.
Okay. So the administrative control, let's look at the community associations first. Or sometimes you call it the period of declarant control. Let me pull up my slide here.
And then while he's pulling that up, John, maybe you can speak to this one. A situation where they have residents who are asking for some kind of a virtual meeting, but then there's other owners or residents that don't even have a computer. Most of those platforms allow for people to call in. Do you think that would cause an issue or a problem with holding a meeting with that format, as long as the call-in option is available?
So first and foremost, we need to make sure that under our bylaws and CC&Rs and code that we're comfortable doing a electronic meeting, whether it be virtual or call in. But yeah, in the end, if an owner can call in to that same virtual number and get the same treatment that they would otherwise get, I'm comfortable with that occurring. Again, predicated on authority in the governing documents. Maybe we're being a little creative to find that authority, but I think we can find that authority with some caution. And you've heard that caution already. But yeah, I think that would work if there's a call-in number. I would just dovetail the last part and say minutes need to be taken of even these virtual or electronic meetings as well. And part of my theme today has been, are these really even valid meetings? But assuming we overcome that hurdle, and they are, we need to have minutes of these meetings.
Yeah, we should be treating these meetings like a normal meeting, making sure the notice requirement is met, making sure that the quorum is met, making sure that meeting minutes are being taken, giving the same provisions that we would for a normal meeting.
We just had a annual meeting conducted along the lines of what I outlined earlier, the 2 steps: notice, the packet, and then nominees, and then a voting process. and it was 302 condo units. We did none of it virtually because, first of all, they didn't have the capacity for over 300 owners to hop on virtually. We did it all through the mails, but we wanted to get things done in this year, and that worked out. And so these even large HOAs, there's a way, if we're not comfortable with the virtual platforms just yet, to still use the mail to do a few things.
Okay. All right, Blake, do you have that answer yet?
Yeah, so I was trying to pull up both of the statutes, but we'll just focus on the Community Associations Act. If you look at Section 502, when we talk about the period of administrative control, what we're talking about is the period of time when the developer or the declarant has the ability to appoint people to the board for the HOA. That's essentially what we're talking about. And so if you have a townhome type development, and they're doing these developments in phases, the developer wants to make sure that these units are built out according to spec, design, all that kind of stuff. And so they want to maintain control of the HOA during that process. And so under the Community Associations Act, the period of administrative control is that period of time in which the declarant has that right written into the declaration to appoint board members to the HOA board, and then owners don't really have much of a say at that point. The declarant can also have a special type of class of ownership and voting rights, I should say. And so sometimes you'll see a Class A and a Class B voting right where the declarant or the developer will have 100 votes per lot, let's say. That happens. And so even as owners are coming into the association and you have, say 50% of the lots are purchased by the ultimate owner, and then you have 50% that are still owned by the declarant, because the balance of voting power has been shifted so heavily to the declarant, 50 to 100 votes per lot, then they really have all the power when it comes to appointing board members. And so the board, obviously being controlled by the declarant, they do what the developer wants. And it can get a little bit muddy. You can see situations where sometimes that line between the developer and the board of directors is not very clear. But really what in fact is going on is you have the developer that controls the board of directors until a time when the owners take over. Now, the issue is that under the Community Association Act, it says, unless otherwise provided for in the declaration, a period of administrative control terminates on the first to occur of the following, and then it gives these criteria. But because it talks about unless otherwise provided for in the declaration, if you've got a declaration that has these terms that are longer than the limitations in the statute, then those terms are going to apply. Except for if you're dealing with condos. Condos are going to have that restriction. And at some point, it doesn't matter how long you write it into the declaration, that statute actually does cut it off. And I don't have it right in front of me, but the condos will get cut off, whereas the PUDs or the regular community association HOAs don't have that same limitation. Does that make sense?
Yep, great. And then one more question did come in for John. Which board meetings are required to be open to all members? And which board meetings can be limited to board members only, like an executive session? And is there a different notice requirement for each type of meeting?
So this is we could spend another hour on just this topic alone, but to be very, yeah, the managers are all shaking their heads knowing exactly what I'm talking about. All board meetings are supposed to have kind of broken up into different components. One, I'm trying to get my camera right here. There we go. One where the homeowners have a chance to say their piece, and then they have to shut up, for lack of a better phrase, and listen. And then the board conducts business, general business, financial reviews, projects, status reports from the property manager. And then in every board meeting, which would be noticed up the same for all these different types of board meetings, there may be an executive session where you can close the meeting to talk about issues with your attorney or obtaining legal advice, discussing litigation, ongoing litigation with a member, discussing a personnel matter like an employee, hiring, firing, that sort of thing. Contract negotiations can be done in executive session because you don't want Timmy sitting in the audience saying, oh, if my brother gives a snow removal quote of $100 less a month, we'll get the gig, and then he can call his brother and give some inside information. So contract negotiations are closed. The general category is if it's reasonably likely to cause the discussion embarrassment of the owner that you're talking about, that can be done in a closed session as well. Again, if you're fearing invading their privacy or causing embarrassment. So those are the categories. There's no special format for, in fact, I think you do get in more trouble than not necessarily legal, but political scrutiny of your homeowners if you're just meeting an executive session all the time, or if you're meeting executive session a lot. People are going to say, come on, I know you're doing more business than the categories allowed in the statute. So be careful of that. The other thing that we could talk about ad nauseum later is work sessions. Many board members just want to get together to chat, free of an open meeting, so they don't have that scrutiny. Because remember, the owners can stay the entire meeting, not just the comment section, unless you adjourn into executive session. So board members often wanted to say, let's get together and just talk about issues A, B, C, and D. The problem we have is Utah Code defines a board meeting as, this is paraphrasing, any gathering of the board where a decision could be made, meaning you've got a quorum. You happen to meet at Denny's restaurant, got a quorum. That's arguably supposed to be an open meeting. So there's some ways around adopting and incorporating work sessions, but that's a separate topic. So all meetings have a executive session component. The notice requirement doesn't change between types of meetings. But if you're only holding meetings that are executive in nature only, I would be very careful because you're going to get called out for doing things in secret.
John, I had a comment on that. One of the problems that I see with a lot of HOAs is that we have boards, and then we have people who are appointed as officers from that board. Technically, those are two different responsibilities, and the open meetings statute controls the board meetings. And so in some context, we've talked about the possibility of using the office, that you are meeting together as president, vice president. One of the things that I always get a little bit irritated about is when people say I'm the president of the board, right?
Yeah.
Well, you're not the president of the board. You are on the board and you've been appointed president, which is a separate hat. And so the open meetings law doesn't really address meetings of officers. And so there have been times when I've said, okay, if you guys have the authority written into your bylaws and your descriptions of your jobs as officers allows you to do certain things, like even meet, then that opens the door for you to be able to maybe have some of these meetings. Although I agree with you, if you just use that as a runaround and you're trying to find a loophole, you're going to come into problems with the members. But that's something that we have talked about. But the problem is most HOAs don't operate that way. They don't operate as though they are officers and board members, and they mostly just operate as a board. And so if you're operating as just a board and all you ever do is board, you never meet as officers or you never do stuff like that, then for you to go and say, all right, now we're going to meet as officers, but your bylaws only say that the president can sign documents, then you might have a problem. And so that may be an area where HOAs might have a little more flexibility if they drafted their bylaws to give specific tasks to officers, including and not limited to actually having meetings together.
Huge. I've been blown away that most people don't understand that their board hat and officer hat's different. That begs another question, which I'll just throw out there. And remember, in the open meeting statute for both community associations and condominiums, there's an exception to the open meeting requirement entirely. It's section 813 of the nonprofit. I mentioned it a little bit earlier. It allows action to be taken by a board without a meeting, but you need to follow the 6 or 7 steps outlined in that statute perfectly, or it's a defective meeting, because we really don't want you having email meetings. Another thing to be thinking about is committees. A lot of the communities that have design review committees, are they open? to the members. They're not boards. They're a committee of the board. And I've got a really ugly situation brewing right now where opposing counsel is saying it's a committee of the board, so it's open. All the board meeting, open meeting requirements apply. And I'm saying, no, they don't. Committee is a committee. A committee is a totally separate body, a totally separate charter, a totally separate set of duties, and the statutes only says board. So be very careful of those nuances. Officers, board members, committee members, what types of meetings and meeting laws apply.
And that would especially be true if the committee only has advisory power and no decision-making ability.
Yep.
So last question, and then we'll go ahead and close. Is there any type of explanation that needs to be given for an executive session? If you're discussing legal matters, do you have to discuss who the parties are in the lawsuit?
Blake, go ahead. I'll let Blake handle that one.
You don't really have to describe what is being discussed necessarily, although there are some, I've got some communities that have within their bylaws, they have to, they have to have meeting minutes of the executive session, and they have certain rules that apply to those. If you look at the nonprofit, oh, sorry, excuse me. Let's see, the open meetings statute. It's going to be in 2. All right, 226 here. In subsection 3, it just says that a board may close a meeting to, and then it gives this criteria of what they can close a meeting to. And it doesn't necessarily require that there's some sort of discussion, preliminary discussion or entry within the meeting minutes of what they're going to be discussing in there, as far as I can tell. But some bylaws actually have that in there, which again makes you remember you got to go to both the bylaws and the statute to do that. What I typically advise is that if you really want to protect what's in that executive session, have your attorney even just come in by phone and appear by phone and have it recorded in some sort of minutes for that executive session, noting that the attorney was present, because then you're not only protected under the statute here, but you're also going to be protected under rules of civil procedure and evidentiary rules as far as that's concerned. And so if it's a really sensitive subject, you're dealing with litigation, things like that, then it's advisable to have an attorney even just call in for that period of time. It's pretty affordable. It's not like you're having the attorney come for the whole meeting, but it adds layers of protection when you have that happen.
All righty, thank you so much for your time, Blake and John. This has been very informative. We've gotten a lot of really great questions. Looks like one person just came in. They're asking about making last-minute changes to when meetings occur. They've given notice a board meeting is going to be on Friday the 13th, 2020, and some last-minute change has to be made. Location change. It's being changed from an in-person meeting to virtual because of the new meeting requirements. Is there anything special they need to do, or just follow their bylaws and governing documents on that?
I'm going to say really quickly, I'm going to say that they need to follow their bylaws and renotice it if there's a change. I had an annual meeting overturned because they changed. It was at a hotel, and they changed rooms the day of. They put a sign out saying, "Please go to room," instead of the room that was on the notice, and that meeting was invalidated for improper notice. So I would stick to your bylaws very strictly.
Great. All right. Thank you so much, everyone. Have a wonderful rest of your Friday and weekend.
Thanks, everyone. We appreciate it.
Thank you.